Alright guys, big update on the case of the state of Utah versus Tyler Robinson, the 22-year-old charged with assassinating Charlie Kirk. Robinson appeared in court on Monday, virtually, for procedural hearing. The most interesting development is that his defense attorney, Catherine Nestor, requested a preliminary hearing. That's a step where a judge determines if there is enough evidence to proceed to trial. But what's raising eyebrows is the possibility that his defense team may be preparing for an insanity plea. Let's break this down.
Very significant moment this morning, the court hearing for Tyler Robinson, Charlie Kirk's accused assassin. It wrapped up earlier today. It was a procedural hearing, and he attended it remotely. He didn't have a camera on him, but we did hear his voice very briefly. Listen.
Into the jail. Do we have Mr. Robinson present?
Yes, Your Honor.
Yes, Your Honor. We heard from Tyler Robinson. His court-appointed attorney, Catherine Nestor, says she wants a preliminary hearing where a judge will determine if there is enough evidence to go forward with this trial. The next court date is set for October 30th. Robinson is expected to appear in person on that date. With that, we bring in Brett Tolman, former U.S. attorney for the District of Utah and Right on Crime executive director. Brett, good to have you with us today. We have pictures of Catherine Nestor, who is Robinson's defense attorney. We also have the team for the other side for the prosecution, Jeff Gray and Chad Granander. We just got our first look at these teams this morning, and we heard just that little bit from Tyler Robinson. Your thoughts on where this stands and if we will actually get a full preliminary hearing, which in Utah is in lieu of a grand jury procedure?
That's right, Martha. Thanks for having me on. I mean, this is obviously the most important case that these prosecutors, whom I know, have ever been tasked of presenting, and I'm very certain they're going to rise to the occasion. He'll be very well defended in this case, and it's important to keep in mind that the preliminary hearing. It's not surprising to me that they did not waive it, which is typical in criminal cases, but not in this instance. The defense is going to want to see a glimpse of the evidence beforehand. This allows them to see how strong the evidence is, what the government has gathered, and be able to prepare a little bit sooner in advance their defense and their strategy before committing, one way or the other as they go through the case.
Yeah, obviously the defense is going to want to be very careful here about not sort of opening any avenue for anything to be thrown out or any procedural problem on their end. Same for the prosecution, of course, in this case. In terms of the possibility of seeking any insanity plea or anything along those lines, let's put this full screen of the text messages exchanged after the shooting by Robinson and his roommate. Roommate, how long have you been planning this? Robinson, a bit over a week, I believe. I can get close to it. The rifle is in parentheses because the assumption is that that's what he's referring to. But there's a squad card parked right by it. I think they already swept that spot, but I don't want to chance it. And then Robinson, I'm wishing I had circled back and grabbed it as soon as I got to my vehicle. I'm worried about what my old man would do if I didn't bring back Grandpa's rifle. I don't even know if he had a serial number, but it wouldn't trace to me. I worry about the prints I had to leave in a bush when I changed outfits. This doesn't sound like someone who's not calculating and understanding the actions that he's allegedly carrying out here, Brett.
Yeah, Martha, in Utah, they would have to be able to show that he was incompetent, and the standard for showing that he's incompetent would be that he lacks the ability to appreciate the difference between right and wrong, and good and bad, and right and wrong, and all of that comes into play, and the government would have to refute that. And some of the best evidence for that is the planning, is the interaction he has with others, in his family, friends, and everyone that he came in contact with.
Certainly. Brett Tolman, thank you very much. We'll be talking to you, obviously, as this moves forward.
So first off, a preliminary hearing is routine, but it tells us that the defense wants to test the strength of the prosecution's evidence early on. It's like saying, show us your cards before we get too far into this trial. And here is the thing, both sides have to be very careful. The defense doesn't want to push too hard and risk a procedural mistake that gets something thrown out. And the prosecution wants to lock this case airtight. That's normal legal maneuvering. But the talk about an insanity plea is where things get really interesting. To plead insanity in the US, the defense has to show that the defendant could not distinguish between right and wrong at the time of the crime. It's not just about having mental health struggles. Tons of people with mental illness still know right from wrong and are fully responsible for their actions. For an insanity plea to work, the standard is extremely high. The defense will need to prove that Tyler Robinson literally lacked the ability to appreciate the difference between good and evil, that he was disconnected from reality to the point that he didn't understand what he was doing. That's a very, very tough sell. Now, here's the problem for Robinson's defense team. Planning. We already know from evidence that he planned this assassination in advance. A text message between him and his roommate shows that he was planning this a week before it happened. That proves premeditation. And beyond that, he was interacting normally with friends, family, and others right up until the crime. That's all evidence that he could function in society and knew what he was doing. If you're sane enough to plan, coordinate, and execute something, and then try to get away with it, you don't meet the insanity threshold. So, could the defense still go for it? Possibly. They might argue that he had some kind of delusional disorder, or that he was driven by psychosis and couldn't resist his impulses. They might bring in psychiatric experts to testify that he was mentally ill at the time. But here is the problem. Juries are very skeptical of insanity pleas. Less than 1% of felony cases even attempt it, and of those, only about a quarter succeed, and usually only in cases where the crime was clearly impulsive, bizarre, or totally irrational. This assassination was none of that. It was targeted, it was planned, it was intentional. I'll say the insanity defense here is a desperation move at best. Maybe there is a 5% chance it sticks, if that. Those are the odds. So here is where we're at. The defense might float an insanity plea just to test the waters, but the evidence of planning makes it nearly impossible to succeed. The prosecution is going to hammer that text message, the planning, and the interactions with others. At the end of the day, this case is likely to move forward as a straightforward prosecution for assassination. Tyler Robinson will be held accountable for what he did, and the insanity plea, if it comes up, will almost certainly fail. But guys, what do you think? Do you think the defense even has a shot with this strategy? Or is this just a delay tactic? Let me know in the comments.